Landlords, why you may want to consider giving your 30, 60, or 90-day notice terminations of tenancy through certified mail, as well as having someone arrange to serve the notice to your tenant as well. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I run into situations where landlords, they issue their own notices. I did a video about registered process servers earlier. Another thing that I run into landlords about is proper service of their 30, 60, or 90-day notice to end their month-to-month tenancy. We'll go, the reason why for different notices are in California, if a tenant's lived there more than 12 continuous months, you have to give them a 60-day notice. Some tenancies, if you're under Section 8, you might have to give a 90-day notice. Anything under the a year, basically, you can give a 30-day notice of termination of tenancy. Check your local listings, though. Tenants Protection Act might apply. So those landlords, that's a whole different topic for a different day. Inside the civil code for terminating a month-to-month tenancy, which is contained at Civil Code 1946 and 1946.1, particularly for residential tenancies, you are authorized under the law to not only serve a tenant as prescribed in the Code of Civil Procedure, which is basically personal service, substitute service on another adult, and mail in a copy of the notice to the person at their residence, or if no one is able to answer the door, posting and mailing, you get to also certify mail the notice, the termination notice as well. That is sufficient in and of itself. Usually what I do as a practice in my office is not only do we give the notice to a registered process server, we also certify mail one to each individual tenant. It is a little bit pricey nowadays. It's like $9 to certify mail something, but it does come in handy in court. True war story here. I actually had one case a couple of years ago where the tenant basically denied they got notice. They were like, I didn't actually receive it. In California, you don't actually have to receive the notice. You just have to properly show a judge that you properly served it in one of the manners required by law. And one of the ways we proved that in court was we brought the rejected or refused certified mailing that was sealed. The little post office puts a little label on it, says undeliverable, refused in this case. And the argument to the judge was, in that case, Your Honor, I have the unopened envelope that we submitted the 60-day notice into. If the court would like to open it and see what the contents of the notice in there, we can do that. And the judge said, you know what, we don't even have to go through that. Mr. and Miss Tenant, you have to open up your mail. That's on you. And that was pretty much a close and shut case from there. So anyway, folks, if you like these videos, please feel free to share them, subscribe to our channel. And if you have any questions, put them down below and we'll go from there. Okay, see ya.